William, hopefully your favorite videographer from Two Hats Publishing. I welcome you to another Two Hats special of community events. Let's look in and see what's really happening.
And good afternoon, and welcome to Lambda Weekly. I'm Dave Taffet here in the studio with Lerone Landis. The late Patti Fink is running very late, but she did say she is coming, so she will be here before 2. Either that, or she'll help them with the Ethiopian show after ours.
She could do that.
She could do that. Yeah, maybe that's what she meant. Our guest today is Ken Upton. He is the senior staff attorney in Dallas for Lambda Legal. Welcome, Ken.
Welcome. Thanks.
It's been a while. Yeah. I didn't realize you haven't been in the studio.
I have not. It's a nice place with nice windows looking out over all the traffic.
Over our plaza and all of our fans who stand outside the window and hold up their signs that say Cincinnati, Cleveland,
France, Croatia,
Oak Lawn. The reason we wanted you on is just to make sense of several cases that have gone on this year, and the one that everybody's talking about, but probably has, well, maybe it does have some impact, but it didn't have the overarching impact that we were hoping it was going to have, and that's Masterpiece Cake. You know, we kept saying it's not about the cake, it's about whether or not a paramedic has to treat you, about whether or not a doctor has to treat you, whether or not firefighters have to come to your house and put out the fire at your house. That's what it's really about. If you can decide, oh, I have religious objections to helping those people, and those people are whatever group your religion says it's okay to discriminate against.
Not only that, you know, do you have the right to go eat in any restaurant you want to? Go to the bathroom where you want to. I mean, the list just runs all kinds of things that we thought this case was about.
And then it was this real funny mixed decision, wasn't it?
Yes, it was. In fact, we found out it was about none of the things you mentioned. It was about this collateral issue about did these poor victims, bakers, get fair treatment by the system, and it's like, how did it become about that? I mean, that was never what the case was about at all.
The cake was two guys who wanted to have a wedding cake baked. They went into this bakery and they said, we're not going to do we're not going to bake a cake for you because you're a same-sex couple.
That's right. Now, this was back in fairness, this was back in Colorado before marriage among same-sex couples was legal in all 50 states. But the law was still very clear that in Colorado, as in many other states, if you provide public services or goods to the general marketplace in the commercial setting, then you have to treat all people on a fair basis. And you know, this whole line of laws goes back to the days when we had Jim Crow laws and public, mostly restaurants, but other businesses too, didn't want to serve people of color in the same setting with Caucasian people, and so
schools were separate schools, buses were separate parts of the bus, everything.
All of that. Movie theaters, blacks had to sit up in the back and the top.
So that, you know, the real surprise question, I guess, David, you should be asking is, I thought we're past all of that, and it appears that maybe we're not quite past all of that. But it's an odd opinion. Back to what you said, it is an odd opinion because Justice Kennedy, who has always been for the most part, very good to the LGBT community in the decisions he's written. He wrote Romer versus Evans, going back to Colorado many, many years ago. He wrote Lawrence versus Texas. He wrote the opinion in Windsor, and he wrote the opinion in Obergefell. And some suspect, although it was not an opinion ascribed to any particular justice, he probably wrote the one in Pavon versus Smith, which is the birth certificate case that came down a year ago out of Arkansas, saying, no, we really meant it in Obergefell that if a couple's married, they get all of the benefits that a different sex couple gets. So historically, he has been someone we've looked to as the person who will tip the court in favor of the issues we care about most for the LGBT community. And he's been pretty consistent about doing that. So it was interesting to watch this case where he seemed to want to split the baby. You know, it's like he said all of the right things about what the law requires. He said, no, these non-discrimination laws are important. Government has a compelling interest in enforcing them, and as long as they're framed in a neutral way so that everyone has to comply, then they're fair game and they don't violate the Constitution. But this poor baker, he was really, really treated badly in the system. And so then he gets off on this tangent about, well, the system seemed biased against him. And so there was a question apparently in his mind about whether the law was being enforced fairly against people who had certain religious views. And part of that stems on something that someone found in the record about a commissioner on the administration side that said, religion's been used to justify discrimination, horrid discrimination for years, everything from the Holocaust to, to
slavery.
To slavery, that was said too. And I think that, everybody knows that when you talk about religion justifying those things, implicit in that is an indictment of the Catholic Church, because the Roman Catholic Church in history has not been terribly good on many issues like those. And so Kennedy, being a good Roman Catholic, I think was offended, and so he turned that case for what you were talking about this is simply affirming the right of states to protect the marketplace so that all people are treated fairly, and turning it to a situation where, but you have to have a system that treats everybody fairly in the process where they're being told that they've misbehaved, and they thought that was absent here. Justice Ginsburg wrote a dissent in that case, and hers is really very, very good. I mean, she said, look, there's no evidence that those random statements by one commissioner had any effect, and if you look at what happened, it clearly was a violation. And so it was very disappointing in the sense that it didn't put the thing to rest once and for all, and a little dangerous for us, quite candidly, because what it did was it breathed new life and a sense of hope into some of these evangelical organizations who have been teeing up all these cases. Two more that are pending currently in the Supreme Court, or will be soon. One is a florist case out of Washington, and the other is a case out of Oregon that was just decided. And so we'll see those come back to the Supreme Court this fall. Now, whether the court will take them or not, you never know. But it's another chance to take another run, and this time Kennedy won't be there. And so it's a little frightening. The good news is Masterpiece Cake Shop hasn't scared off courts that are smart enough to know what to do. Just the week after the decision came down, an appeals court in Arizona looked at Masterpiece and even quoted from it and said, well, this doesn't change anything in our case. We have someone who discriminated on the basis of sexual orientation. It's forbidden under the statute. The law applies evenly, and there's no bias in our case. So that one could also end up going back up because the Arizona Supreme Court has refused to hear it. Sometimes state Supreme Courts do the right thing and refuse to hear cases.
We're not used to that in Texas.
We'll talk about that. But generally speaking, you're going to see this return, and this time you'll see it return without Kennedy. And so Kennedy's replacement will have a significant impact on what, or could have a significant impact on what will happen the next time.
So going back to the Masterpiece cake case, some people thought, okay, immediately the reaction was, oh my God, this pretty much gives everyone the license to discriminate based on religious beliefs across the land. And then, other attorneys were saying, no, this was a very narrow ruling. How so? Why doesn't this just give freedom to people? Because this one cake baker did win.
Well, he did win. And he won on a technicality. I think the best example I can give, we've always had laws that frown on clear bias in the judiciary. Texas aside, most states don't like a lot of bias in the decision making that happens in juries or by judges. And so even though you may be guilty, you're still entitled to a fair proceeding. An example I could give is if you went out and assaulted David. You know, you attacked him, you brutally
he
kicked
threatens
him
me all the
and
time.
All the time.
and with no justification. And they arrested you, and they tried you, and they found that the judge was biased against you on something completely unrelated. Maybe he had an objection to people of color. He thinks they always commit crimes, and so they're suspect, and we shouldn't give them the same benefit of the doubt. And so he holds you holds you accountable and says that the evidence really wasn't there. I looked at the evidence, but I still think you might have done it. Well, the court would look at that and they say, well, race shouldn't have played a role in it. And if the evidence wasn't there, he shouldn't have found you guilty anyway just because he thinks you might have done it. You would get reversed. Your conviction would get set aside.
Gotcha.
But if your conviction gets set aside, that doesn't mean assault's now illegal in the state of Texas. It doesn't mean everybody can go out and it was a specific technicality about the way you were treated in the process. If the evidence not there, then you should be set free. If the evidence is there, then you should be convicted. In this case, the evidence was there, and they set them free anyway. And that's the analogy I make is that the result was about the proceeding, not about the underlying law. The law is still good. In fact, the court said there's nothing wrong with Colorado protecting the public marketplace against discriminatory acts. And they said that's a compelling issue for governments to address. But in this particular case, they kind of put all that aside and focused on this technicality and said, well, in this case, he gets to go free.
So wouldn't a better way to handle it would have been just to send it back down?
Well, yeah, there's some argument about whether that would have been the more appropriate proceeding or whether it could even be refiled. Now, it probably can't because it's been so long since that happened. I mean, this happened back before Obergefell and before Colorado had marriage. You remember Colorado had marriage before Obergefell. So it's been a long time, and there are limitations on how long you can rebring it. I don't know what the law is, but since it's an administrative claim and not a criminal claim or a civil claim, then I think that it's probably time barred anyway, but there's probably not the stomach to try to do it again.
Right, but they're going to do this again with the flower shop.
Over and over until eventually the court's going to have to say, this is the law.
Okay, so I'm assuming with the flower shop, it's a gay-owned flower shop that discriminated against a straight couple?
Kind of. You got it a little backwards, but...
I have that. So they were able to find a florist that was run by straight people.
That in and of itself ought to get them a medal.
And so this is a closeted florist, or we don't know?
We'll call it that. Actually, it's a woman.
Okay.
It's Arlene's Flowers, and interestingly, the woman who owns it is not named Arlene. I don't have a clue who Arlene is, but so it's fraudulent to begin with.
Arlene is a guy named...
Arlene is the owner's drag name.
So here's the interesting thing about the Arlene Flowers case. The Washington State Supreme Court unanimously ruled against the florist. Okay, well, it has gone up to the Supreme Court,
and it was returned.
And they vacated it and sent it back down.
On what grounds?
Well, they said re-examine the record in light of Masterpiece Cake Shop to see if there was bias in the proceedings similar to that we found in Masterpiece. Is it being evenly enforced? And so it's basically not a complete do-over, because what they're doing now is they're examining for something they weren't necessarily looking for before. But it'll come back.
Is there any indication that there was?
No, and the people who are familiar with the case and familiar with the record saying there's absolutely none of that here.
So one of the arguments for discriminating is it's my business and I can serve who I want, and if you offend me, I just don't have to do business with you. Isn't it also an argument, and I haven't heard this argument come up particularly, but the argument for you have to would be you rented a retail space, it's in a city, it's on a street that everybody's taxes paid for, including some of those people that you don't like. Sidewalks also are provided by people that you don't like, the police that protect your business and other businesses on your street, the fire department, all those are paid by taxes. Isn't that the argument, that that's the reason that you have to treat everybody equally?
Yeah, it's actually even bigger than that. It is the entire creation of a commercial marketplace is something that benefits the public, and that the public benefits from when they access it. Mm-hmm. And so it is about the infrastructure, but it's about access to even something more intangible, the marketplace itself. And that is, if you don't want to do that, you can just provide services to the people in your church. Mm-hmm. And not people who aren't in your church. And there are people who do not do commercial endeavors, and it comes up in other areas, whether or not you have to be licensed. Sometimes it's determined by whether you're in the public sphere or the ecclesiastical sphere. There are people who do what's called counseling, but it's not counseling in a healthcare license sense, but they do it through their religious organizations, priests or rabbis or other types of clergy counsel their parishioners, and they don't have to get licensed. Mm-hmm. But if they go out into the public and they're just doing counseling as a licensed professional counselor, mm-hmm. then they're entitled to be regulated, and they're entitled in exchange for accessing the public to meet certain requirements. Licensing's one, non-discrimination's another in some places. Mm-hmm. In all places, it's some form or another, but non-discrimination laws are kind of a patchwork.
And in the case where, I don't like all of these whatever people, and so I'm just going to provide cakes or whatever for people in my church, you're applying the law evenly to everybody. I don't do straight people outside of my church. I don't do gay people out of my church. I don't do white people out of my church. I don't do black people. I don't do any of those. Right. So you're applying it equally. I'm just offering it to this particular group that is my religious community.
Right. Yeah. And there's nothing wrong with that. Mm-hmm. But when you step outside the church, and we privilege church in our society. Some societies are smarter than to do that, but there still are limits. They can do things inside their church. They can't walk out and translate that into the public, mm-hmm. and that's just the way it should be. If you want the marketplace to thrive, then you have to have it open to all of the people who need to participate. So,
mm-hmm. That's kind of like that church on Greenville Avenue that was advertising a sermon coming up, the dangers of Judaism, but they're advertising in all kinds of public venues, and some people took offense. I don't know why. People are so touchy. You're listening to Lambda Weekly on 89.3 Knon FM. I'm Dave Taffet here in the studio with Lerone Landis and the lady Patti Fink, who is on her way, she assures us. She'll be here for the next show. We'll be back with more. Ken Upton from Lambda Legal is our guest.
Hi, this is Valletta Lil, and I listen to Lambda Weekly. I hope that you will too.
And this is Lambda Weekly. I'm Dave Taffet here with Lerone Landis. Patti is expected. Maybe we should call her the expecting Patti Fink.
No, she's not pregnant.
Oh, she's not dead either. So.
We don't know either of those things at the moment.
Well, that's true. I don't know them.
That's very true.
Ken Upton is our guest. He is the senior staff attorney at Lambda Legal here in Dallas, and has worked on a number of these cases that we've talked about whenever Ken's been on. The Houston case. Houston has this odd history with non-discrimination. It's the only major city that doesn't have some kind of non-discrimination ordinance. And I'm not talking one that includes the LGBT community. I'm talking about
just one, period.
They got nothing.
Yeah. But they did pass one. And
it got repealed.
They passed one that included us, and it got repealed or challenged.
At a time when they had a mayor who was gay, and she said, it would be nice at some point if I could provide health insurance for my wife. And the whole time she was mayor, she paid for it out of her own pocket, as opposed to other mayors who get it provided. There was a case in Houston about providing benefits, equal benefits. And the same group that came up to Plano to try to overturn the ordinance up there, did overturn the ordinance in Houston, and then sued for to stop this horrible practice of providing health insurance and other benefits for people's families. Tell us where this case stands, and because the Supreme Court, the state Supreme Court, has overturned or sent it back.
Well, talk about what led up to all of that.
Yeah, I mean, it's an interesting case. This case actually started in 2013. That's how long it's been
prior to Obergefell.
That's right, and prior to Windsor, actually, or right after Windsor, I guess. And Windsor was actually the impetus when it came out. Mayor Parker, who was the mayor back then, asked her city attorney. She said, "Well, I've read Windsor, and I know it only applies to the federal government, but I'm having trouble seeing how, if the federal government can't treat marriages inconsistently, how a state government or city could do the same without running afoul of the Constitution. It looks like it's the same analysis." Mm-hmm. Bingo, it is. And the city attorney's office gave her back an opinion, said, yes, there's no justification for the state or the city to do it if the federal government can't do it under the Constitution, because they're both government entities. And so she, on her own, issued an executive order and instructed HR to start enrolling the people who are employees who are legally married. Now remember, marriage wasn't available in Texas, but who were legally married in some other jurisdiction, which was the case in Windsor. And if they are legally married, then they should be eligible to apply for spousal benefits. We had a number of people apply within days of that order, and immediately this group of taxpayers, and by group I mean two, filed a lawsuit against the mayor to stop the benefits before they could go any further. We filed a suit to stop the taxpayers from stopping the city, and the federal court stepped in, and the whole thing kind of got frozen in time. And then the next thing we know, Obergefell comes down. And after that, there doesn't seem to be any issue left, because the states have to follow by the same rules that the federal government does. If you're legally married, then the state must recognize it. And moreover, the states now have to let you get married.
Now, doesn't Obergefell say something about you're entitled to all the rights and benefits of marriage?
That's right.
So which rights and benefits in the Houston case were you not entitled to that Obergefell said you were entitled to?
Well, the taxpayers said that they have an ordinance actually they have part of the city charter that says the city may only provide benefits to employees who are legally married and basically don't violate the Texas Defense of Marriage Act. So what basically they're saying that the city can't, under that charter amendment, do that.
Is it legal to pass an ordinance based on a law that has been found unconstitutional?
Yeah.
Well, when the charter amendment was passed, marriage wasn't legal everywhere. And but now that Obergefell has come down and Windsor has come down, it's pretty clear that the charter amendment, what it actually says is you can't have, it's really convoluted analysis, you can't have benefits for employees unless they're legally married under Texas law. Well, now they are legally married under Texas law, but the taxpayers say, well, that's not what it meant. The taxpayers aren't using any kind of attorney lens. They're using a policy lens in which they want to try to stir voters up and things. And
here's another question. Before it even got to the Texas Supreme Court, why wasn't it thrown out on standing? And by that I mean, if I have no stake in what happens, I can't sue you to stop what you're doing with him over there because it doesn't affect me.
That is true in 90% of the cases. There is an exception in Texas. Now remember, they're in state court. Mm-hmm. There's an exception in Texas that if you're suing a municipality and you are a taxpayer, property taxpayer of that municipality, you have taxpayer standing to challenge an expenditure that you say is violating the law. And so they came in under that narrow window. if they wanted to say the city shouldn't be providing those benefits in federal court, they'd get kicked out on their can, just like you're talking about. But Texas has and they couldn't sue in state court in Texas for the state doing it. You don't have taxpayers standing to sue the state. But there is a narrow exception in Texas for taxpayers to sue their city.
So as long as these taxpayers lived in Houston
and pay property taxes, not just live there. They can't just be renting.
Oh.
They have to own property.
Okay.
So it's about being a property taxpayer in a city that gives you the authority to challenge what you call as an illegal expenditure of funds.
So it did get up all the way to the Supreme Court, and the Supreme Court found what?
Yeah, so this all happened before Obergefell, after Windsor, but before Obergefell. It got up. The taxpayers convinced a local family court judge, who has some relationship with the chair of the Harris County Republican Party. You know, we do have elected judges here, so they were very smart where they filed it, and they got her to enjoin the city. The city took it up on appeal to the First Appellate Court in Houston, and it sat there for a long time. And in the interim, Obergefell came down. The Texas Court of Appeals, which is not the most liberal court, but at the same time, they're not a bad court. I mean, we've gotten some pretty good decisions out of the first. They said, well, now that Obergefell's come down, and De Leon, which is the Texas marriage case, it's clear that the law is that they must recognize the marriage, and they have to provide them the same benefits. Mm-hmm. No brainer. That's what it said. And so they reversed it and sent it back for proceedings consistent with De Leon. And the taxpayers said, no, we're going to get the Texas Supreme Court to review it. They filed in the Texas Supreme Court. It sat up there forever. And then finally the Texas Supreme Court declined to hear it. They said, we're not going to hear it. It was an 8-1 decision with Justice Devine dissenting. But 8 of the 9 justices said not going to hear it. That should have been the end of it. Mm-hmm. It should have been over. But because our government doesn't operate the way most governments do, there became this intense lobbying pressure, partially instigated by the attorneys for the taxpayers, getting all of the most evangelical churches riled up, getting the Republican legislators riled up. And there's phone call, letter writing, emailing campaign to all of the justices on the Texas Supreme Court. The Attorney General filed an opinion, the governor filed a letter, and all of them basically, some of them pretty nasty. They're in the record. You can go back and read them, about threatening the judge's re-election if they let this stand. And lo and behold, the court granted hearings.
So there are letters that actually show extortion, and nothing's been done about them?
Yeah, not extortion. I would say they just said things like, "This isn't why we elected you." You could read that both ways, but I think the implication for somebody who has to go run for election again is clear that this could be an issue in the next election.
Okay, so if your elected officials, like legislators or a mayor, is doing something and you don't want them to do that and you want to voice your opinion, they have mechanisms for people to record what you're saying. And so a few weeks ago, when students from Santa Fe High School were here in Dallas and wanted to go talk to Ted Cruz's office, it was considered kind of illegal that they kept him out of the building. It's just not what you do. Normally, an elected official like that will have them in, they'll say their piece, "Thank you very much for coming, please sign in," and then they leave, right? Judges don't have that.
No. Well, they do have a system for people weighing in on a case, and it's by filing in a brief with the court in the normal process that meets all the requirements of a filing, usually by an attorney, but some individuals could file one. But they don't have a way for you to contact the justices directly. And that's actually an ethical violation. For someone, if an attorney encourages someone to try to influence a judge outside of the system, that's considered basically tampering with the judicial system. And so I'm surprised there haven't been charges brought against the people who were promoting this, but some of them were doing it through the channels. The governor and the attorney general filed theirs formally, and it was filed of record. But the people who were calling their chambers on their phone and leaving messages, and we heard that the clerks in the Supreme Court were baffled. They didn't know what to do with all this. It was the first time they've ever had
something
this.
you do.
And so their way to deal with it was they memorialized, they saved all the voice messages and emails, and they put them in the record. And so it was like, well, it was filed in the record. It's like, but that's not a part of the record. That's not the way the system works. So it was a shocking thing. The court reheard the case, and lo and behold, they all did an about face, and it was a unanimous decision that it needed to be sent back for a do-over.
So it was 8-1 not to hear the case,
and now it was 9-0.
9-0 to
we heard it, and we think it needs to go back. Yeah, they didn't decide anything. They said, these are all these questions that need to be answered, but we're not going to answer them in the first. It needs to first go back all the way back to the original judge and start through the system again. So they got a do-over.
So how in that process did it go to the U.S. Supreme Court?
Well, the city tried to get the U.S. Supreme Court to hear it, and they did not take it. And that wasn't a surprise because it wasn't final. The court, if you look at the actual opinion, the Texas Supreme Court hypothesizes about all the things that might still be issues that someone needs to sort out, but they don't express their opinion, although it's pretty clear that they think it's open season for the judge to start over. And so it wasn't surprising. We didn't think the U.S. Supreme Court we didn't join that. Lambda Legal didn't join that petition for cert because we didn't think that chances are that they would take it. And if they did take it, it would say a lot for meddling before cases are final, and that's not what the Supreme Court does. So it's not over. It's back, and in fact, it's back at square one. It's like nothing ever happened, except now the law is different.
So the question that the Texas Supreme Court left was, does Obergefell leave open the right to offer different benefits to the two classes of married couples?
Right.
But Obergefell never establishes two classes.
That's what the Texas Supreme Court
That's what I'm
said.
saying. That's what they... So in the trial court now, I guess what they need to prove is there aren't two classes of marriage. In fact, if you were to ask anybody how many same-sex couples have married in the state, they'd have to say, we don't know, because nobody keeps track of that.
Right.
I mean, even the day after marriage equality, I went down to Pauline Medrano's office to ask her, and she said, you know what? We know some straight people got their marriage licenses yesterday. We don't know how many gay couples married. I can tell you how many licenses we issued. Total.
Yeah.
Total.
Well, so that's one of the issues is whether there is room to treat people differently. Now, the taxpayers have a new argument now. They're saying, well, you can still enforce the Texas DOMA and not violate Obergefell. You just don't provide spousal benefits to anybody. Then you're treating them all the same.
Oh, wow.
The city didn't think that was a great idea, especially if you want to be competitive as the fourth or fifth largest city in the country. That's going to be kind of a problem. And it's also a little disingenuous when the state is providing benefits to spouses. They have to. They're under an injunction from De Leon to provide the benefits. So there was the issue about, well, do you have to provide the benefits? There's an issue about the taxpayer said, well, even if going forward you do, they shouldn't have been providing them back then because Obergefell hadn't come down yet, and so we should at least be able to make them to get that money back from all the people that they provided benefits to. I represent some people who don't think that's a very good idea because they are employees who did take advantage of the benefits. So, I think it'll be interesting to see. We filed a case to keep them in federal court, to keep them from it's really kind of amusing to keep them from doing this a third time because they've had two orders now from this judge, and this will be the third time she gets to consider it. And we filed it, and our judge in federal court dismissed us and said, well, you're premature. The judge hasn't had a chance to rule the third time, and surely the things have changed. I can't imagine that the judge would do it a third time.
Now, the case that you mentioned before, Pavone, how come that didn't play into this? They were just ignored.
Well, it was raised with the court at at the time of rehearing, because it came down between the time the Texas Supreme Court said we'll hear it and the time they actually heard it. Pavon came down, and we cited that to them, and I can't explain to you how they got around that. You just have to read the footnote where I can only say that a law clerk must have written that footnote and not had a clue how the law works, because it's nonsensical, and if any justice read that, then I question why they're on the Texas Supreme
Because
Court.
Pavone says that benefits have to be provided equally.
That's right. That's exactly what
and
it said.
reasserts what Obergefell says.
That's right.
It doesn't make sense.
Some errant law clerk who thought he was doing something noble, I guess.
We need to take a break in just a minute, but there was a case that is in the courts. Rob Wiley is the attorney, and he got a positive Title VII decision here in the 5th District.
No, it's actually in the Northern District.
In the Northern District. Okay. How important is that?
Well, it is, although it's a little more complicated than that. So this is a case that Rob had filed some time ago, and there are two theories that people are advancing around works. For those who don't know, Title VII is the law that protects you in the workplace from discrimination or hostile work environment based on a number of factors, one of which is sex, discrimination based on sex. We have been very successful in the last couple of years at getting the federal courts to re-examine their doctrines around what sex means, and courts are starting to turn and say, well, it's nonsensical to say that it doesn't include sexual orientation and gender identity. That's clearly a component of sex that is present, and so Rob filed a case making the argument that Title VII should cover discrimination based on sexual orientation. The courts had already many years ago said, well, it covers discrimination based on the fact that you don't conform to sex stereotypes. So if you're a straight man but you happen to be effeminate and that causes you to be bullied, then you would have a colorable claim if you wanted to file one. If you're a woman and you weren't feminine enough, you were too butch, and so they were treating you differently, that would be said. But the Supreme Court's never actually said, does it apply to sexual orientation? So some people are starting to push. So there are two theories. One is, well, if the person doesn't conform to what you think a man or a woman should act like or look like, then that's sex stereotyping, and that's clearly covered. But what if it's a gay man that does conform? What if it's like he looks like every other man that works there, but you know he's gay and you hate gay people? Mm-hmm. That's a different type of Title VII claim, and that's based on sexual orientation being covered outright. It's your identity as a gay man that's covered, not your mannerisms as an effeminate man. Mm-hmm. Stereotyping coverage, and those are the two, and those are the areas that courts are grappling with. Cutting away.
Yeah, we do need to take a break. It just seems to me that
we'll come back to it.
Okay, why don't we come back to that? You're listening to Lambda Weekly on 89.3 Knon FM. I'm Dave Taffet here in the studio with Lerone Landis. Patti is on her way. Well, she said she is. We'll be back with more with Ken Upton in just a moment.
Hi, this is Pauletta Lil, and I listen to Lambda Weekly. I hope that you will too.
And welcome back to Lambda Weekly. I'm Dave Taffet here in the studio with Lerone Landis, and not Patti Fink, who is on her way.
No, she's not.
Oh, she's not?
She's not.
Oh.
I just checked my phone.
Oh, okay. So she's
back.
Let you know. Okay.
Yeah.
Patti, feel better. She actually texted before the show. She wasn't feeling well, but wanted to get here. Ken Upton, the senior staff attorney from Lambda Legal here in Dallas. And your area covers how large a region?
Eight states, including Texas, Oklahoma, Kansas, Nebraska, Colorado, New Mexico, and Louisiana.
So it must be easy for you because you got all the liberal states.
I don't have Mississippi or Alabama.
Oh, that's true. That's true. Sorry. Okay, so we're talking about this case where, sex discrimination is either being covered or not being covered under Title VII, and we got a positive ruling this week in Dallas.
Now, what's interesting about this, though, is that when Rob originally filed the case, he was going after pure sex discrimination. Didn't matter if you knew he was gay or not. When you found out he was gay, then you started mistreating him. The court actually said the law doesn't recognize that. Then he went back and amended, and he said, but even if you don't buy that, they clearly thought he was gay because of the stereotyping around the way he lived his life, the way he dressed, the way whatever evidence he has. And the judge said, well, now that states a claim. Now you're starting to see the craziness of the Title VII law. It's like you can be gay and someone just finds out but couldn't tell otherwise, and then they could treat you like crap. But if you act gay, and whether you are or not, then you're protected. And it's like, how is that make
Josh,
sense?
our board operator, will be fully protected for everything.
So what about the situation where you have a gay man who's conforming? You really can't tell him the difference between him and the other male employees in the workplace. But nobody knows he's gay. But then you find out he's always said he was married. Everybody assumed it was a woman. You find out that his spouse, in fact, is actually a man. Then there starts discrimination. Would that fall with sex discrimination? Because now you're discriminating because of the gender of his spouse.
That is one of the arguments we make around why it doesn't make any sense to have this artificial line, because that is classic discrimination because of sex. And so now this judge, she might say, no, it's not covered because you weren't stereotyping him as a gay man, you didn't even know. Or she might say, oh, once they found out, it's a stereotype because I have a view of who men should marry, and it's not other men. I have a stereotypical view. It is the madness of these two approaches that just are incompatible. And we're actually starting to turn court. So now back to Rob's case. The reason Rob's case is so important, and it's not the first case in Texas, but it is the first in the Northern District, as far as I know, where a judge has had to grapple with this distinction. And even though he didn't convince her on the broad coverage for Title VII, he did convince her that he had a sex stereotyping claim, which is silly. If he was discriminated against, he was discriminated against. If it was covered, it was covered. And so his case gets to move forward. Now, move forward in the federal system doesn't mean quickly. He has to do discovery, and he may have a trial. He may not have a trial. They may have papers that they have a decision on. But he has a chance now to tee that up for the Fifth Circuit. And the reason that's important is because the Fifth Circuit covers Texas, Louisiana, and Mississippi. So there's a lot of coverage in those three states. And I think that we were talking on the break. There's a highly respected judge in Houston in the Southern District of Texas. Her name is Lee Rosenthal. She's the chief judge, and she had a Title VII case. It was a transgender case instead of a sexual orientation case, and she said, well, I first have to decide if a transgender status is covered, and she went through the analysis of all the recent cases and said, although the Fifth Circuit hasn't had a chance to look at this, I think it probably is. Now, then she turned to the facts that were pled, and she said, but you didn't plead a case that shows there was really any discrimination or discriminatory action or something. So that person didn't get any farther along, but at least you have a judge down there saying, well, this actually makes sense to me that it would be covered. And so I think you're going to start seeing more of those cases. There's a couple of cases pending in the Supreme Court for next term. They haven't taken them yet. One out of Florida and one out of Missouri. And those two cases, the Missouri case isn't up there yet, but the Florida case is pending. And if the Supreme Court takes one or both, depending on how they turn out, then the Supreme Court could decide that issue.
And mentioning the Supreme Court, we have a new possible justice about to be sworn in.
Well, he hasn't gone for his hearings
I know, but I think he'll skate through it. What do you think?
Well, it's going to be tough to stop it. The Democrats don't have a majority, and they've done away with the filibuster. So the chances that he will get confirmed, and we're talking about Brett Kavanaugh, the chances that he will get confirmed are pretty high. There are a couple of Republican senators who could vote against. Remember, John McCain's not in right now. He's ill. And so they really don't, they have a very narrow margin of success. If you could knock off two senators, and if all the Democrats would hold together, that's not also a foregone conclusion.
Right.
Then it is possible you could block him, or at least delay him for a while. I mean, the thing about Judge Kavanaugh, he is a judge currently in the D.C. Circuit, and he has a long paper trail. He was involved in the Ken Starr investigation against the Clintons, so he's a very political person, despite what people would like to paint him as. He has said in his writings that he doesn't think the president is subject to the special counsel or an investigation while he's in office, and that if he thinks the law is unconstitutional, he's free not to enforce it. So he has a very troubling position on executive power and the power of the president, especially at a time when there seems to be more and more evidence that something is amiss in the executive branch around the Mueller investigation. So.
If a president is free not to enforce the law that he thought was unconstitutional, does that just apply to Trump, or did that apply to Obama too?
Well, Obama Obama supported the law in terms of its enforcement. However, he didn't support it in the challenges on appeal. The Department of Justice actually didn't defend it before the courts, which is a different issue than are you going to enforce it until it's overturned. So he straddled that line in a way that I thought was interesting. Now the DOJ's done a reverse, and they're back to fighting for everything that's evil in our world. But so I think that it'll be interesting to see. And the big thing about Judge Kavanaugh is he has some pretty extreme positions. He'll make Neil Gorsuch look like a moderate, and it's sad to think that John Roberts is now the median vote on the court. I mean, he's really kind of in the middle. I wouldn't call him centrist by any means, but
he's the median.
But he's the median. He's the middle, and so. If Kavanaugh gets on, I think it is almost a foregone conclusion that Roe versus Wade will be gone in some amount of time. It may be whittled away further, but affirmative action's at risk. All kind of. He was a judge on the D.C. Circuit that was opposed to the Consumer Protection Commission.
Because protecting consumers is bad. Why?
Well, because it's unconstitutional. It hurts businesses. And businesses are people,
Yeah. Does he have any paper trail regarding any LGBT cases?
Not a lot. We're still looking, but most of the things that he's touched involve the administration's role and regulation of the government. He has taken some pretty harsh positions against the Affordable Care Act, and he's also was one of the votes in Hobby Lobby about the rights of businesses to be protected in their religious discrimination in healthcare. So
this is one that has really confused me, is that Hobby Lobby case.
Me too. I
understand businesses can have a religion. In Judaism, though, we don't have a way to convert a business. In any Christian denominations that you know of, is there any formal way that a business can convert?
Do you know if you have the right to do it? Have you tried?
No,
it's
but
a good time. It's a good time in the court system to test these things.
That would be an interesting thing to do. Well, maybe get an arrangement
let me
about
give
the
you
religion.
let me
Get
give you
on
an
that.
assignment. I would start with Prestonwood Baptist Church, and then if you're there, go down to First Baptist in downtown Dallas. I think if you can convert those two to Judaism, then
No, I'm talking about a business like
They're businesses.
Well, I know they're businesses, but I'm talking about like the newspaper where I work or the law firm
Catholic
where
hospitals.
Lerone
Catholic
works.
hospitals are everywhere. Private hospitals are run by religious organizations all over the place, and they do exercise their Catholic doctrine in the provisions of services. What was the case involving the person under confinement? And the state took them to a hospital, and she miscarried, but they wouldn't perform the abortion.
Or the DNC or something.
Or something. I can't remember, but it seems like we've heard stories of that happening in a lot of hospitals where they delay as long as possible, hoping that God will have His way. So,
wow. And the woman can die.
I don't know that she died. I think they did eventually intervene, but she almost died. So I mean, like.
Well, I guess you're right. Businesses can have religion. We just have a couple of minutes. There was an interesting case I wrote about in the Dallas Voice this week. I wrote about it last year. Two women who were dating at the time went to the home of one of them, and middle of the night they woke up and they saw this man in the bedroom. He had broken into the house. Turns out there was a window that was not working in her first floor apartment, and he opened the window and climbed in. She had a repair order for the window. What had happened was the window had previously been repaired with just caulk, and so this repair was to latch the window because it wasn't latching. They put in new latches, but on caulk it just easily opened. It wasn't latching into anything. So they were saying the apartment complex had partial liability for this. At the trial level, the jury awarded them a considerable amount of money. Went to the 5th District Court of Appeals here in Dallas. The 5th District last week overturned the decision, saying that the apartment complex couldn't have foreseen a break-in. They're arguing now that, of course, they might not be able to foresee a rape, but the reason that we have ordinances in every city that you have to provide locks on doors and locks on windows is because we expect that there are going to be a certain number of break-ins into houses, into properties. So you lock a window, you lock doors. You just do that. What are your thoughts on that?
Well, I mean, I don't do premises liability cases, but the law's all over the books on what constitutes foreseeability and not, and that I've always thought that if you can convince a jury, then that's probably the consensus of the way that reasonableness should be determined. I mean, that's the whole idea of why we have juries, and so it's a little odd unless there's an exclusion for landlords outright. It's a little odd that the Fifth Court would decide that as a matter of law they couldn't be held liable. I mean, I think it is problematic when reasonableness is determined by if it ever happened before, because I can think of a lot of things that I reasonably expect could happen, but that doesn't mean that I've actually seen them.
And the attorney was saying, I could see if I had to argue that there needed to be guards on premises, security guards.
Taking unusual measures.
Unusual measures you would have to argue for. But locking your doors, locking your windows isn't an unusual measure. Windows are designed to lock just because we know people break into houses all the time.
Yeah, so. I have been broken into before, so I do appreciate that. I think that the bottom line is that we trust the jury system because on the average it works, and so I don't know what the court's going to do. Send it back, I guess, but
he hasn't decided exactly what he wants to do with this case, but he is going to ask for a rehearing, whether it's en banc for the whole court or the interesting part is 2 of the 3 judges who were on that panel are up for re-election this year. So, and that is here in Dallas. So, Ken, thank you very much for being with us. Ken. As always when you're on, you're a wealth of information. So,
thanks.
Are there? I guess there are a couple of upcoming cases like Arlene's completely straight flowers.
We'll just have to watch and see what happens this fall.
Come back and we'll talk about any cases like those when they happen. Have a good week. For all of us at Lambda Weekly, we'll be back with you next weekend.
This is William, hopefully your favorite videographer from Two Hats Publishing. I hope you enjoyed this video. If you like it, please leave comments below, or like, follow, or subscribe to us and get notices of all our videos. We love it, even when you call.